Hi everyone, thanks very much for tuning into the recording today. It's a pleasure to welcome Geoff Bloom, who's a privacy law expert, and we're going to be talking about privacy updates and how this has been highlighted by the recent European privacy laws, known as the GDPR. So I just wanted to introduce Geoff. And so Geoff is a lawyer and partner at HWL Ebsworth, and he practices in regulatory and commercial law for the health, aged care and life sciences industries. And he also specialises in privacy and freedom of information law. As well as working in private practice, Geoff has been a principal legal officer at New South Wales Health and at the Cabinet Office for the New South Wales Government. And he's taught health law at UNSW. And Geoff has been named in Best Lawyers Australia for healthcare and aged law, life sciences practice, and privacy and data security law. So Geoff, thank you so much for joining us today.
It's a pleasure. Good to be here.
Thank you so much. So Geoff, with the recent privacy updates, could you give me a little bit of an overview of the GDPR and what it is for optometrists?
Yeah, absolutely. So the GDPR is the EU privacy law. It stands for the General Data Protection Regulation, and it's coming in really soon, just in 3 days on the 25th of May. And why are we interested in Australia in it? Firstly, more than probably any other privacy law, it's got a whole extraterritorial reach. And so if you are offering goods or services to people in the EU, then you become subject to the data privacy law, and you may have to comply with it, and also be theoretically subject to the penalties if you're not complying.
For sure. So with GDPR, who does that apply to at the moment?
Okay, so it applies to data controllers and data processors. Data controllers are the ones that decide what you do and why you're doing it in terms of personal information, and data processors are the people who, like contractors, will do it for a data processor. So, for example, you're an optometrist and you engage a marketing firm to do your marketing for you. You tell them, I want to reach out to EU because I think that I've got some sort of products or services that, I guess particularly products that are of interest to the EU. You are the data controller, and if you want to collect the information, the contact details of people in the EU, you're in that capacity, you're data controller. The marketing firm that you use to assist you is the data processor. They might do the actual legwork. So that's how that operates. If you are indeed, it doesn't apply just because you've got a website and people from the EU can access it. You have to be more actively facing the EU for it to apply. So that means things like if you've got pages on your website that are in non-English European languages, for German speakers, click here, for French speakers, click there, that's very clearly targeting EU customers. Likewise, if you've got things like euro price tags on your products or services, again, that will be seen as you're targeting EU data subjects, as they're called, and so be subject to the GDPR as a result. Now, in many ways, if you're complying with Australian privacy law, a lot of what you're doing will be fine for the EU as well. But there are a number of higher bars which the EU privacy law imposes, and that's the fact that it has a higher standard is reflected in the fact that Australia is not characterised as an equivalent jurisdiction for EU privacy law. There are some jurisdictions, including Argentina, Israel and New Zealand, in fact, where you don't have to take extra precautions if you send personal information from the EU to those jurisdictions, whereas we're not seen to have quite as high privacy protections, and so you have to take extra steps if you're sending information from the EU to Australia. What that means for Australian businesses, if they're subject to the EU privacy law, is again they have to comply with some higher standards and higher requirements. Things like for direct marketing, if you have a customer relationship, the person has to express affirmative consent in order for you to be able to send them direct marketing. That's a higher level than under Australian privacy law, which requires things like an established business relationship and a reasonable expectation on the part of the optometrist that the person won't mind receiving direct marketing. So the person in the EU, you have to have expressed affirmative consent. You have to have opted in. So that's one example. There are quite a lot of interesting things about the law. Just in fact, I think for everyone, because we're all affected by privacy law, and even as consumers, we're all affected. And as time goes by, our personal information is a more and more valuable commodity, and businesses and governments tend to be more intrusive in the way that they collect our personal information and combine it and disclose it to other people. And so the EU law against those increased intrusions has put in increased protections, and that affirmative consent is an example of an increased protection. But there are other ones which may not be even as they will apply to you if you're subject to the EU privacy law, but they're also just quite fascinating. Things like the right to be forgotten, a duty of a right to erasure, as it's called. If I don't want you to hold my personal information anymore, then there are a number of circumstances where I can simply tell you that, and you have to delete all of your information, or all of the information you hold about me. And that was actually, that right was triggered in a European court case that came down about a year or two ago, where a Spanish guy who had a criminal record that was completely stale, that was still searchable on Google, and so he was not able to get jobs because people would Google him and find this criminal record, details of his criminal record, and he said, well, that's not fair. I can't be held to account for things I did many years ago. I actually should have a right to ask Google to scrub their records, and so that's the right to erasure, or right to be forgotten. Those kinds of things, really are changing the way that businesses and governments relate to individuals.
Yeah, for sure. So if I'm using Facebook ads to target my patients, and one of them happens to be on holiday in London or outside or in Europe, so how should I do the privacy laws apply to me there as well?
Mainly they wouldn't, and especially in those sort of small scale things, in a practical level, I don't think you would be worried. It's more, and in fact that's an important point in itself. You don't have to just avoid contacting people in the EU because of this new privacy law. It's only if you have a more sort of serious and proactive engagement with a sort of customer base in the EU that you'd really be concerned about compliance issues.
Right. Okay. Yeah, that makes sense. And yeah, as you said, even though there might be on a website we might get hits from the EU, if the intent that we have isn't to try and attract people from there, then we're relatively it's a low risk for us.
Absolutely. And it doesn't, and likewise, if you do get the odd customer from the EU who just, happens to light on your website and wants to buy products, there's no prohibition or anything involved in this new privacy law because of that fact that they're from the EU. You should just go ahead as you would have before.
Yeah, for sure. Yeah, that's really good.
Mm.
So the GDPR, it brings up an example of thinking more about privacy policy and how we go about handling information. I know that Optometry Australia has some templates and some other guidelines about it, but I'd love to get your input on what do you think about, what are some of the main things that you think about when you thinking about privacy?
Okay. Well, privacy is an important part of optometry practice. Obviously it's a health profession, and people care about how their personal information is used and disclosed, and they particularly care about it when it's health information. And so, and that would be a concept that's well familiar to all optometrists, that you need to take care with someone's personal information. In fact, health information is classed under the Privacy Act as one of the type of sensitive information, and that attracts additional protections. The Privacy Act regulates what's personal information. That's the cornerstone of privacy, and personal information is information about an identified or identifiable individual. So if it's anonymised, not of interest to the Privacy Act. If it's aggregated data, not of interest either. It's only when you're down to unit level data, that's information about Joan Bloggs, of such and such an address, that she has glaucoma and she's been in to get these glasses. All of that is personal information and regulated by the Privacy Act.
Okay.
And so for an optometrist, there are, I guess, a few things that are really just basics and that you need to have in place and that the public will expect. The Privacy Act says you need to have a privacy policy, and I imagine that you mentioned there are templates available. I would think that one of those would be a privacy policy. And a privacy policy is a document that probably would go for about 2 pages, and it sets out to the world at large how your business handles personal information. This is the type of information we collect. This is how we collect it. We collect it from you when we have consultations. We collect it through our website. We collect it when we get referrals from other health professionals. This is how the people we disclose it to. We will disclose it to other health professionals. We'll disclose it to health funds, to Medicare, that kind of thing. You have a right to access your personal information from us. For example, if you want to get a copy of your prescription, you have a right to request that and we must provide it. Likewise, you can ask us to correct your personal information if it's not right. And also, you have a right to make a complaint if you think that we've done something wrong with your privacy. So that's a privacy policy. It should sit, generally people have it as a link at the bottom of their homepage. It will say privacy policy and you'll click and be able to get to it that way.
Sure.
The other thing that's sort of like a mini privacy policy is, they're called different things. It might be called a privacy notice or a privacy consent, or it might be as part of your new client/patient admission form, a little blurb about privacy, which is sort of a condensed version of that content in the privacy policy. And the function of that is that when you start a relationship with a new client, you're telling them basically what you do with their personal information, so they can work out, do I want to part with my personal information? They know what you're going to do with it, and so that just helps them then to decide what they want to give of their personal information. So those 2 documents are kind of cornerstone documents that every optometrist should have as just a starting point.
For sure. And yeah, it'd be ideal to show both of those on the bottom of your website.
Well, actually, not that the privacy notice is more one that it's not a passive document. It's not one that people come and find. It's more one that's active when you initiate a relationship with a new client or patient. Then you provide it to them. You've actually got to give it to them at the time.
Right.
Or likewise, if on your website, some people now you can book a consultation just on the website. When people are doing that, you're going to be collecting their personal information, and if it's a first-time customer, it'll be for the first time. Again, at that point, you should have a link to, we care about your privacy. Here's how we do it, and then your privacy notice appears. So it's at that moment in time when you're initiating the relationship that you have to provide that document.
For sure, yeah. And talk to me about storing that information. What sort of steps do we need to do to protect the information, say, for a new patient?
Yeah, well, there's under one of the Australian privacy principles, it relates to security, and it says that you need to take such steps as are reasonable in the circumstances to prevent the unauthorised use, access or disclosure of personal information. So, that means there's physical security, that, you can't have a whole lot of patient files on the front desk where other customers can see them. You're not supposed to let your customers sort of wander through the shop and into the back where you've got your admin area, again, so that people can't access the personal information of other people. But then there's also IT security, that you have the patient notes in a login protected area. You have sufficient firewalls and security so that basically it's protection against hackers. People can't just casually access that information, and you're expected. The level of sensitivity of the data will drive what sort of steps you're required to take. So a bank is going to have much more sort of robust measures than an optometrist, because that information is more valuable to third parties who might want to do things like rob identity and so on. But nevertheless, it's personal information, it's health information, needs to be protected with sufficient IT security.
Yeah, for sure. And when we're thinking about cloud backups are becoming more popular now, some encrypted backups. But how do we think about knowing whether we can use a provider or not?
Okay, well, certainly, there's nothing at all wrong with cloud providers, and they're common now, and they tend to be, more economical. So, a lot of people use them, and that's all just fine. You definitely do want to use a reputable one, because there have been security breaches with cloud providers, and so your duty to ensure security of your data comes into play in your choice of a reputable provider. That's one thing. Ideally, probably there's an industry standard which is where I guess you'd say best practice is that you'd use a cloud provider that is only keeps their information in Australia, not offshore. There's certainly no legal prohibition against using offshore cloud providers, but in the health industry, I would say that the more common than not practice is to use one that says that they'll only keep their information in Australia. And there are reasons I won't go into, but there probably are some, some persuasive reasons why that's a better way to go. Things like that foreign governments can't access that information in a way that if it's overseas they may be able to. So, absolutely go with a cloud provider, make sure they're reputable, and ideally in Australia.
For sure. Yeah, that makes sense. You'll avoid any geography or other changes that could upset the way that you back up, or it's just safer overall.
Yeah, that's right. And things like, for example, My Health Record, which is the Australian government's national health record system, that's mandated under legislation to be the information can only be kept in Australia. So it sort of just shows you a kind of industry standard practice there.
For sure. Yeah, that sounds good. So if we're thinking about maybe you're a practice that's wanting to create, maybe you don't have a privacy policy at the moment and you're wanting to create one for the first time, how should you go about notifying existing patients that you've updated your privacy policy?
Well, okay, so there's I mentioned that obligation to, when you initiate a relationship with a client or a patient, to notify them of certain things about how you handle their personal information. But let's say that you're one of the many practices that hasn't done that in the past. What I would suggest doing is to do a sort of refresh privacy notice, where you'd send out an email to all your clients saying, we've been, we care about your privacy, and we've been developing our protections for you. We wanted to let you know how we handle your information, and to let you know that we take great care with your personal information, and here's our privacy notice, which has a link to our privacy policy. And so that's a good way to sort of bring yourself up to date and sort of ratify any previous activities that you've done with their personal information.
For sure. There's everyone gets a lot of email these days, and sometimes people will see the email and open it and be able to view the privacy policy if they want to. But sometimes that email might get missed. So if someone happens to miss that the initial send out, do we need to go ahead and resend that to the people who didn't open the email?
No, you don't. It's really a sort of a formal obligation. If you've brought that information to their attention, they don't need to actually absorb it. In the same way as you'll, in lots of online types of contracts, you'll say, click here to read our terms and conditions. You don't need to have read them. You just need to have been given the opportunity to read them, and that's the same here. It's not something that you need to monitor to see, did they open it, or do I have something more to do for those people who didn't open it? You simply, just the sending of it will put you in the clear.
Okay, that's fantastic. So that updating the privacy policy is it's a great time thinking about these changes with the European GDPR. But it could also be a good opportunity if practices are looking to start using some of that, creating Facebook ads. So if they use mobile phone numbers or an email address to be able to send ads to their patients, it is important that they notify beforehand.
Yeah, now that's a really key information. I guess for optometrists, I divide up the privacy issues kind of into three categories. There's the formal compliance stuff that you need to do, which is your privacy policy and your privacy notice. That's one group of things. So, you need to tick those off your list. There's the health information side of things that, you need to keep that secure because it's people's personal and indeed sensitive information. You need to have good security and confidentiality, all of that. And then the third category is marketing type purposes. You don't just use personal information to provide the service to your client. You also use their personal information to market to them, to send them, information about new offers. Have you come in for we haven't seen you for a year. Have you thought about having another checkup? That sort of direct marketing. Now, you can do that certainly through Facebook and through social media. You can also do it through sending emails, through SMSs, and a lot of people will do a combination of all of those. Now, if you're going to do what we call direct marketing, we're actually sending to a targeted recipient through their email address, say, or their mobile phone number, then there are some restrictions about how you do that, because it's basically things like spam that people don't want. There's only so much information people want to receive, and so there are legal restrictions there under things both in the Privacy Act and in the Spam Act. And so basically, I mentioned it a bit in connection with the EU privacy law, but under Australian privacy law and Spam Act, what you need to have is a established relationship with the person, and they need to reasonably expect that you will send them those kinds of commercial messages. So if they've been a client of yours before, you would have that established relationship, and they'd expect to receive things from you about optometry, not about cheap airplane tickets. That wouldn't come within the scope of what's permitted. But if you're advertising about optometry, then you're in the clear. The example that's given is if it's a client, then you have that sort of relationship. If someone came in and just bought a can of Coke from you, even though they're a customer, you don't have any sort of established business relationship. So, but generally optometrists, I think, whether you're providing a service of, eye tests and so on, or even if you're just selling someone a pair of glasses, I think that generally that would be sufficient to establish the necessary level of relationship. You need to keep a record of their name and address and the contact details, obviously. You need to also keep a record of opt-outs, because if somebody opts out, you need to action it. And if you fail to action it and you send them subsequent communications, then you breach the law. And, as well as that, people just get shirty when you do that. It's not good customer relations, because someone might be, a really happy customer of yours, really happy to come back. They just don't want you to send them these damn emails. Yeah. So if someone's opted out, both for legal compliance and also customer relations reasons, you want to respect that. So there are, I guess, some people can have dirty databases where they've collected information in other ways. They've gone to got the fishbowl from the local cafe where people drop their business cards in, and they've just taken those details. Those sort of things where it really has no connection with your business. If you're going to send marketing information to those types of people, then you are at risk of breaching laws, and also, again, just putting people's backs up. So there is an issue about the quality of information in your direct marketing database. And, it's a really valuable asset of the business, actually. And so you need to keep the quality of it, sufficiently high. And in fact, even, having acted for optometrists on when they've been selling their practices, that's a significant part of the value of the practice is the customer list and the contact details. So you've got to have a high quality one to maintain the value of what you're offering if you are in that position of thinking about selling your practice as well.
For sure. Yeah, keeping that, if you can say that it's a quality list, then you're more likely to get better value for your practice anyway.
Absolutely. And, and it's something which you can, if you work on it, you can really increase the size of your list, but also increase the value. Obviously some people do better at maintaining that relationship at a distance through those sort of communications, and so it increases the value of your list if you're doing that kind of thing.
For sure. Yeah, that's a great point. So, yeah, just going back to before when you mentioned terms and conditions, is that something that would be ideal to have on the website too, just so it's publicly available?
So terms and conditions, some websites have terms and conditions, like terms and conditions of the use of the website. Um, there are often things which web developers will sort of throw in as part of the package. They're all right. They're often pretty generic and, in that sense, not particularly adapted to the particular business. So they're of some use, but of limited use. I guess the thing is, probably the more important thing with that is, when you have offers and you're particularly doing things, like buy a one set of glasses and get the second, get lenses for a second set for half price, that kind of thing.
Sure.
You need to, if there are sort of conditions, sort of fine print type things, those things need to be of equal prominence, so that if someone's seeing the ad, they'll also be able to see the conditions. That, for example, the lenses can't be of a higher price than the initial pair. That kind of thing. You need to make those kinds of riders reasonably visible. That's actually, to me, that's the more important issue for terms and conditions type things. So that people don't actually try and take up a deal and then find out, well, actually, it wasn't as good a deal as I thought. There are all these qualifications which don't make it so valuable anymore.
For sure. So if I'm running a competition on Facebook and I've got an asterisk score, I want to point out terms. I could have people click through to the page to find out the conditions for that offer.
Absolutely. Well, in that example, competitions are regulated under legislation. Each state and territory has its own legislation, but the gist of that legislation is that it's got to be a real competition. You can't just offer people to win a free car if they enter the competition and basically give you their customer details. If there's no actual car going, for example, it's just a sort of bait and switch thing to get their details. So that's the gist of those sorts of things for competitions, and you do have to actually state the terms of the competition. This is going to run for this period of time. That this is the prize that's on offer. This is how you enter, that kind of thing. So that raises its own issue. Competitions are, obviously it's a fairly common way of kind of igniting some interest amongst customers. So it's a really good strategy in certain circumstances. But yeah, you just have to make sure you're complying with the requirements if you're going to do that.
Yeah, for sure. Yep. That's.
But these competitions are great. Definitely, really great for that thing of boosting the size of your mail list. On the one hand, but I guess the people who are entering aren't necessarily the people. They're not as likely to buy from you as your existing customers, for example. So it increases the size, but you may be getting people in there who are less likely to be actual customers at the end of the day as well.
Yeah, for sure, and that could be we have a potential customer list separate from the actual customer list, and be able to bring people across once they've become a customer.
Yeah, that's right, and that's also it's great to be able to segregate your data in that way, because it can tell you things like, well, I spent $1,000 running this competition, and I ended up getting this much new business. So it's good to actually keep track of that, and that's not such a difficult thing to do with IT these days, to keep track of those kinds of things.
Yeah, for sure. It's a great way to show that you put money in, and here's what you've been able to find.
Yeah, absolutely.
Yeah. Well, Geoff, it's been great to talk to you today about privacy and how the GDPR highlights the need to think about our privacy and make sure that we've got an up-to-date privacy policy. And you work with optometrists and you create a customised privacy policy. So what's the best way for optometrists to get in contact with you?
Okay, well, certainly we do work with optometrists and a number of businesses, and always love to have more. So if people want to contact me, they can Google me. I'm at Geoff Bloom, GEOFFBLOOM. I'm a partner at law firm HWL Ebsworth. I specialise in health law, and there are not so many lawyers in Australia who do that. So although I'm in Sydney, I've got clients in pretty much every state and territory in Australia, so that's not any impediment. And they can just email me or call me, and I'm very happy to talk to people.
Yeah, for sure. And before they contact you, is there any helpful information that you'd like to know before that first contact?
Well, it's helpful if I can know the nature of your business, if you're a sole practitioner, or if you're part of a group. It's useful to know what sort of things you're doing at the moment with privacy. And I obviously do advice in areas broader than privacy, but if we're talking about privacy, it's useful if you can send me copies of your existing documents, and that way, we can kind of just get moving quicker and make the process more efficient.
So if you're just starting a practice, it's a great opportunity to take a global view and be able to cover all the areas straight away.
Oh, absolutely, and that's I definitely like to deal with new practitioners because it's just we can get you set up in a really kind of nice sort of on a firm footing, and that's just a good basis for a new business.
Yeah, that's great. It's good to get off on the ground running. So, yeah, that's great.
Yeah, no, I always like helping new businesses.
Fantastic. Well, Geoff, thank you very much for sharing your expertise on privacy and really appreciate your time today. Thank you.
Oh, it's a pleasure. Really nice to talk to you.
Thanks.